you'll need to email that to Mr. Chamberlain, okay?
I am emailing
Your
it
Honor.
as we speak.
Madam.
Your Honor, just for clarity, did you also order no contact with the victim?
Yes, I thank you, madam. No contact with the victims in this case. Ms. Seaburn, you understand that, right?
Yes, I understand.
And
Okay.
co-defendant,
Yes, I understand.
All right. And that means your family as well, okay?
Yes, sir.
Okay, all right. Unless there's anything else, then that'll be the order of the court, okay?
Thank you.
All right, good luck.
thank you, Your Honor.
You're welcome.
Thank you, Your Honor. May I be excused?
Yes, ma'am, you certainly may, and thank you all for your patience.
Thank you.
All right, let me go back to, I was just, let's see. Okay, Mr. Geary, Mr. Smith, just for your situation awareness, I believe for number 15 on the plea arraignment calendar, Mr. Garlington, he'll appear at 2 p.m. Yes, because of the notes. Okay, all right, wonderful. All right. Okay, Antonio Sumlin. Is Mr. Sumlin been, or is he on the platform? Let's see. Do we have any updates on Mr. Sumlin, Mr. Geary, or?
He is either in DeKalb County, and he is an attorney, I'm sorry,
That's okay.
attorney, Mr., I think it's RAGAS, has filed an entry of appearance.
One more time, what's his last name?
RAGAS. Arthur Regas. Arnold, I'm sorry, has filed a entry of appearance, I think it was just last week.
Okay.
But I believe, my last information is that he's not been brought to Rice, that Mr. Sullivan is still in DeKalb County.
If we could, if you have any identification, custodial identification for him, we'll go ahead and put him on the 8th of September, and we'll see if we can reach out to Mr.
So what we really waiting is for Jeffrey Lamar, Young Thug,
R.A.
and Sergio Kitchens. That's the two names we waiting for, but they are in
First
court
name
right
Arnold.
now.
Okay, all right. Okay, Cormarius or Cormarvius Nichols.
No attorney is yet to our knowledge, Judge. He should be in Rice Street.
Yeah, Mr. Nichols, are you on the platform? Let's see. Lieutenant Dooley, do we have Mr. Nichols on the plan or availability? Cormarvius, I should say. Nichols, he's supposed to be in 5N 613. Okay, we're gonna hold that one for location, and I think that
I wish I could bypass all this shit, but these niggas is
I'm
live.
sorry.
What happened with position 12? Mr. Dorsey, he's supposed to be brought over from the cast. I didn't get an announcement.
He was continued, Judge.
He doesn't have an attorney, so I'm gonna put him on for the 8th, Mr. Chamberlain.
Judge, on position 9, Mr. McCollum, he should be at Rice Street, but we showed him with no attorney.
Yo, salute to everybody tuning in. This shit is
I
live.
believe that, yeah.
These
Mr.
niggas is
Mullen,
actually
I think we
live.
took care of already. McMullen.
So I can't
Yes, we
fast
took care of
forward
him
it,
already.
but Young
I
Thug,
spoke to him, and we're gonna
Gunna
put him
is
on
on
for
the
the 8th of
bottom
September,
left
see if we can get him on,
of
an attorney.
the television screen that they all on.
Yes.
I think they trying to find Thug to bring him in now.
Yeah, I took care of it already.
On my soul.
Okay.
I ain't even really up yet. I just fucking rolled over and seen this shit. I was like, oh shit.
Mr. Farley, are we still holding?
Salute to everybody pulling up though. Y'all know the
I'm here for that,
vibes.
Your Honor.
On my soul, I'm about to roll up one too. But it's not just their court date. It's a couple of other people. Whoever's on that little screen back there. So we just gotta
Mr.
wait to hear the
Farley?
name Sergio Kitchens
Okay, all right.
and what's this nigga Young Thug
Come
name?
on,
Jeffrey
Mr.
Lamar.
Mateus.
Now this is a motions case. Now I mean, they already was denied bond a couple of times, but this is a motions case. So we gonna see.
And Your
man,
Honor,
we
I'll have
listening
one
for
witness.
Jeffrey Lamar
She's logged in now
and
with
Sergio
her
Kitchens,
audio
man.
and video muted. It's Miss Patricia Ford.
Miss Patricia who?
Ford, Your Honor, F-O-R-D.
I'm trying to see if I can find her.
Judge, can we put something on the record, please?
Hold on one second. Let me see if I can find her to begin with, okay?
Your Honor, her box is next to Mr. Farley's, actually, coincidentally,
I'm gonna move her.
to the right.
Now I see her. Okay. Ms. Ford, can you turn your camera on for me, please, madam? Okay. Mr. Geary, you want to say something, sir?
Yes, sir, I just want to put on the record, Judge, we were told this bond hearing would not be on the calendar. We would announce not ready, we will follow the court's instructions.
Your Honor, this was on the calendar that was mailed out to us, and it says on there, motion to reconsider bond.
Mr. Geary, I'm going to go forward and it's a motion to reconsider bond. So tell me what's changed since the last time that I considered bond for you, or for your client, I should say.
Yes, thank you, Your Honor, for the opportunity. There's a lot that's changed.
Because I denied him bond back in May the 23rd of this year.
That's correct, Your Honor. That's right.
All right.
That was all based on proffers made by the state and the defense before discovery had ever been sent out. And so, Your Honor, I do want to correct several misstatements that the state made about Mr. Farley at that prior hearing, so that the court now has a more nuanced, full picture of things to take into consideration with the other things presented, as well as the Ayala factors. Your Honor, there was a lot of proffers about the murder count that Mr. Farley is alleged to be a party to. We've since gotten the discovery. The warrant affidavit itself alleges no party to a crime allegation whatsoever. It alleges just mere presence and mere association, Judge. And I've now done a little investigation into Mr. Farley's clothing company, which is what brought him into all this in the first place, Judge. And so I do want the court to consider that together with some proffers. And I understand the state's position about the privacy of the discovery and that they have a pending motion about us not sharing discovery outside of our legal staff. And I would also, for the record, they have made some implications about the defense counsels in this case, yet they're using Dropbox, which is a private third-party company. So it's entirely possible that someone within their office or someone within Dropbox has connections to social media and, TMZ and stuff like that. So I would ask, Judge, if we could do an in-camera inspection of some very small portions of the discovery, specifically the BP video that the state referenced earlier at the prior bond hearing.
Did you put that in your motion?
No, Judge, I didn't.
Because I'm going to take up that on the 8th. So if you want to proffer or have me consider that, file a motion. I invite you to put some suitable facts and law in there like you're doing right now, and have me consider it and have the state respond to it, okay?
Yes, Judge, and may I continue?
Yes, you may. Go ahead.
Yes, so in the case that bond is denied today, Judge, I will return on the 8th with that in-camera motion. But for now, Judge, I'll proffer what I find different to the state, Judge. For one, the state implied at the prior hearing that Mr. Farley knew these people very intimately, that he greeted them when they walked into the BP. But, Your Honor, what actually happened is there's a Fusion and an Audi. The Audi is alleged to have Mr. Shannon Stillwell in it. The Fusion is alleged to have Mr. Quamarvius Nichols and Mr. Farley in the back seat with Quamarvius driving. And so the Audi and the Fusion are at this gas station right around from the juvenile court, Your Honor. And then the deceased pulls up in a car. And when that deceased leaves, the Audi follows him and the Fusion follows him with Miles in the back seat of the Fusion. The license plate readers confirm that the Audi is in front of the car that Mr. Miles Farley is in the back seat of. And Your Honor, it's this mere association with Mr. Quamarvius that led him to be there. He's not even a driver of one of the cars. And he doesn't actually greet anyone when he walks into the BP. Mr. Stillwell and Mr. Nichols are standing at the cashier, doing something playful with the cashier. And Mr. Farley later gets out of his car from the back seat, walks into the store by himself, and doesn't acknowledge Mr. Stillwell or Mr. Nichols. And as he's walking by to get something, Mr. Stillwell turns and does this playful, bucking kind of playful thing and startles Mr. Farley, who then playfully turns around and continues to go into the store. And then out of the corner of Mr. Farley's eye, he sees Mr. Stillwell and Mr. Nichols about to just leave him there. And so he, in a panic, scurries away, follows them out the door. They don't even acknowledge him any further. They turn his back on him and they leave, Your Honor. So the association and the presence here has more nuance to it than the state alleged at their proffer, Judge. And so what I contend to this court is it's corroboration of what I presented to the court initially, that Mr. Farley, he's a graduate of South Atlanta High School and Miles University, and all this time at 24 years old, has never been convicted of anything besides a misdemeanor amount of marijuana.
So when Young Thug and them
Judge, which is a typical teenager,
they're going to have
thing.
a motion for bond.
Your Honor, he has no criminal history.
To reconsider bond.
With a business degree,
so the lawyers is actually going to put up a little fight today.
It's called Make America Slime Again. It's a play on words. In the hip hop industry, there's a lot of this. You put the word trap or slime into something that's already part of pop culture. It's just good business, Judge. It's something people already recognize. It's something that's kind of humorous. And this is one of the shirts, Judge, I have for you to see. This was a new shirt after Make America Slime Again off of the Trump logo or slogan. Now there was Keep America Slime. So all it is, Judge, is these hats and shirts that took the Trump merchandise, replaced it with this word slime, which is not always criminal. And like every word, and especially that word, it's context dependent. It's like the word dude. It depends who's saying it, when are they saying it, who are they saying it to, why. You could be my dude. You could step on my shoes and I could be like, dude, what was that? You could be that dude. There's so many things. So slime on its own means nothing because it can mean so many things depending on the context. So that's all he's doing, Judge. He's making these clothes.
Son is wild.
He sees a business opportunity.
You don't know what the hell
he's friends with Mr. Wonnie Lee, who's the creator of the hip hop persona.
That nigga don't know what he's talking about right now.
And as his friend, he becomes his personal
nigga said slime is the same thing
he gets
as dude.
Music videos on time, stuff like that. He's actually paid by the label that's not even YSL.
Bugging.
And then, Judge, he's using the proximity to celebrity to take advantage of just attention, which is a top commodity these days.
So apparently this person they talking about is another person that's caught up in that RICO.
In these music videos worn
in
by
the
these
YSL
artists
RICO.
Is a way to make money. And he's born and raised on Cleveland. It's not just a tattoo. He's raised on Cleveland Avenue. His dad's also an entrepreneur. They call that area Little Haiti because there's not a lot around, so you have to be an entrepreneur. So here we have a young man, college educated, never been arrested for a felony, and he's making his clothes. And instead of sitting there and maybe, selling them on the street next to the people, doing the lamb chops or selling the Powerades, he has this brilliant idea to go on tour with Mr. Wonnie Lee and sell to fish in a barrel these suburban kids that go to these concerts. And I can proffer, Judge, as an officer to the court, I remember what that environment was like, back in 2008, going to University of Michigan, go to the Kid Cudi concert, buy the t-shirt. And I almost want to say that I do remember there was a shirt where they had Kid Cudi as the Obama campaign thing at the time. So similar to what's going on here, Judge. It's like a deja vu. And so I admire Mr. Farley. He's very smart. He's well educated, and he found an opportunity to make this clothing. And then the state, because he's wearing this shirt that says slime or die, again, a play on words, if Your Honor remembers the Get Out the Vote campaign, Vote or Die. I think it might have been P. Diddy or some people at the time were pushing that. Again, Judge, just artistic play on words, proximity to other artists who are in music instead of clothing. And that's all this is, Judge. So on the Ayala factors, he hasn't ever threatened to tamper with any witnesses whatsoever. He's barely in any of the discovery, this 5 terabytes. It's not even everything, but he's barely in it, Judge. He pops up on the scene because he returns home after going to college instead of going out of state. And, I admire him for that. He's a family-oriented person. He has a child. The mother of his child helps him with the clothing company, Your Honor. And his father still stays there in the barbershop on Cleveland Avenue. And so I just don't see now, with having the discovery and knowing more about the clothing line, how we can deny Mr. Farley's bond. He can't be considered any risk, let alone a significant risk of reoffending, because he's never even been accused of a felony besides this. And the warrant affidavit itself, to this day, along with the discovery, alleges no assistance or any of the other 5 ways that you can commit a party to a crime, in addition to being the principal. It does not say that. It just says that he was driven somewhere by Marvius, gets out of the back seat, gets back in the back seat, and then the car is behind a car that's alleged to be involved in a shooting. And we don't even know the circumstances of that shooting. It doesn't even seem planned. It doesn't seem to be connected to anyone the way the other murders are alleged to be connected, Judge. And so he can't be considered a significant risk to reoffend. He can't be considered a danger to the community. He's college educated with no criminal history. He can't be considered a flight risk. He's cooperative the entire time. He is arrested without incident, without flight, no attempts of flight. He's had his communications monitored this entire time. I know that the Fulton jail even has voice recognition that knows when people are using other people's phones. It's not anything like that either. And so, Your Honor, the state does allege that he's present at a public forum, a public hearing with Mr. Wani Lee at some point. But again, Judge, he's his personal assistant. And all that the discovery alleges is that Mr. Farley told him where the courtroom was. There's no threatening. There's no witness intimidation, Judge. His communication has been monitored this entire time at the jail. And he just can't be considered a risk for any of the Ayala factors. And so, Your Honor, we just asked for the bond to be set in a reasonable amount, given the severity of the charges, to add some harsh conditions. I propose for the court a bond of $100,000, that he stay at the address that we provided to the court at the prior hearing, 2894 Browns Mill Road in Atlanta, Georgia, zip code 30354, and that we put him under the highest pretrial level of supervision and a 24/7 house arrest, and even take away his internet access. He can conduct his business through assistance without having to actually access the internet himself, Judge. That way, there can't be any worry about him contacting any witnesses or anything like that. And so, Judge, I do want to call Miss Patricia Ford very briefly to say a few words about Miles. She's his high school principal. She knows him very intimately over several years, and she can speak as well to the Ayala factors, Your Honor. So I would want to briefly call her and then allow the state to respond.
All right, Ms. Ford, can you unmute yourself? Ms. Ford, can you unmute yourself, please?
Yes, good afternoon.
Madam, can you hear me?
Yes, I can.
You're gonna have to speak up just a little bit. I'm gonna administer an oath to you, okay?
Okay, that's
Can you
fine.
raise your right hand for me, please? You solemnly swear or affirm the evidence you'll give in the matter now in hearing should be the truth, the whole truth, and nothing but the truth. So help you God or so affirm?
Yes, I do.
Okay, you can put your hand down and you have to speak up. Use your outside voice.
So my name is Patricia Ford. I was Miles' principal for 4 years. Miles, he was my student. He was like my son. Everyone knew Miles was my student. And if Miles didn't do his homework or he just didn't do anything on task academically, they would bring Miles to me and I would just address Miles like he was my child. Everyone knows the love that I have for Miles. He performed well academically. He's a short kid by stature, but just a mighty soul and a mighty person. A lovable young man who went off to do great things after leaving South Atlanta High School. And so as a school, we all know Miles, we love Miles, and have just been taken aback by what he's being accused of just because of his disposition and demeanor that he portrayed and demonstrated while at South Atlanta. Never got into any trouble while at South Atlanta. He may have gotten into something his senior year for horse playing. He is known for just being a jokester and
What does
playing at
that
school, but getting
mean?
into fights
Respectfully.
never happened at South Atlanta High School. Not
Why
my
do you
4 years of
have
knowing him.
your principal there?
Just an overall good kid.
Nigga's not a kid no
Thank you,
more,
ma'am.
champ. Respectfully.
And just to be clear, you were the principal. Was Miles ever accused of any kind of misconduct or suspended from school or anything like that besides the horseplay that you mentioned?
Nope. Not at all.
Because they trying to get bond
And
for the YSL case niggas. You know what I'm saying? So this is somebody
Did you
else
stay in
that
touch
that
with
got
Miles
arrested
after
for
you
the whole
graduated?
YSL shit. And they
Yes,
didn't get
we
no
did.
bond.
He would come.
So they
by the
trying to
school
get this
when he
nigga
was on
bond right
vacation,
now. So they gonna
from
go through a
school.
couple of
He
people.
would always
But we
talk
listening
to
for
another
Sergio
staff
Kitchens
member at school, and I would
and
keep up with him
Jeffrey
through how-
what the fuck is dog name?
Okay, and as
Jeffrey
a principal,
Lamar
do you
Williams.
sometimes have a sense when you're observing these students in their formative years, which students might get into trouble in the future and which you feel like, no way, that's gonna happen? And which of those buckets did Mr. Miles Farley fall into at your discretion as a principal?
This would be the one that would never get in trouble. Because of his home bringing by his parents. He was just like a good kid, like we would say, just raised the right way. So just knowing that he's caught up in this is just taking many of us aback at the school who are still there, who knows Miles.
All right, thank you, ma'am. And then if he requires any of your assistance while he's being supervised and released on bond, would you be there for him to support?
Absolutely.
All right, thank you, Ms. Ford. Those are all my questions.
State, have any questions of Ms. Ford? Okay, all right, Ms. Ford, thank you very much. I'm gonna put you back on mute. You can be excused to go back to your usual duties and avocation, okay?
Thank you.
All right, thank you much, ma'am.
Bye-bye. Bye-bye.
And Your Honor, that's all I have at this time, except for a brief opportunity to respond to anything that the state might say.
Okay, what says the state? Go ahead, Mr. Geary.
I'll just do it from here.
You can sit or stand, sir, whatever your pleasure. I know we've been here a while. And it's about time for me to take a break, so.
No problem, Judge. Judge, contrary to what counsel just indicated, there is actually nothing new from the bond hearing from the 25-23, Judge. On that date, and what counsel wanted to do was argue the sufficiency of the evidence at trial, which is again not what bond is about. Understanding he's presumed innocent, but we have the evidence. We've got the videos. We've got all the evidence there. Further, if we want to talk about the evidence respectfully, Mr. Farley instructed his girlfriend and or baby mother to dispose of a phone and dispose of a gun before we could get there. She didn't. We got it. So that's there. We've got Instagram posts by Mr. Farley basically saying forever homicide. Now, that's not a clothing. That's in line with YSL gang, with other gang members. You know, he's got the tattoos. He can't hang around YSLs and falsely claim. He's got the tattoos, and he's hanging with other YSL members. So he's not falsely represented.
Uh-oh, got him.
Video. He wants to say
here goes the prosecution.
Mr. Lee's assistant. He's in the video throwing gang signs, armed with a weapon. I'm not sure if
Here
that's
goes the
job
prosecution,
description.
champs.
As an assistant. He is seen numerous times on Cleveland. They say he's raised on Cleveland. Raised on Cleveland is the name of the predecessor gang to YSL. That is a street gang. If people want to just say, oh, I was raised on Cleveland, that's a gang identifier, Judge. Sliding it out. He would be the first criminal to try to make $1. Judge, the fact that he might have a clothing line on theirs, and I will say that for Mr. Williams also. Mr. Williams has made an interview that stated the gang pre-existed the record label. It pre-existed the clothing line. That's recorded statement by him. So anything that's marketing after that is an opportunity. I'm not saying they're not taking advantage of that. That doesn't mean they're not committing the original crimes. So just the fact that he is trying to make money off of selling something that is gang related, that has got nothing to do whether he would commit an offense. And I say this kind of left-handed respectfully. I know counsel didn't make an admission here, but he states the recording does show he's there on the scene at the time of the murder. It does. And it shows a lot more than that, Judge. He characterized the recordings. It's going to be for the jury to determine that. Judge, this is basically the same thing was presented to you on 523. You found that there's no reason, there's no evidence presented to change that ruling, Judge. Yes, or no.
Okay, all right.
Yes, Your Honor.
You got a minute?
Yes, just a minute, Judge. I agree with a lot of what the state said. Yeah, making a clothing line and using artistic content doesn't connect you to crime and make you a criminal. Just like wearing a Scarface shirt or a Godfather shirt doesn't make you part of the mafia. It's art. What Mr. Williams is making is art. It's spread all over the world. And now Mr. Farley is a bystander, Judge. What the state didn't correct was that, yeah, he's on the BP video, not doing the things that the state proffered he was doing at the original bond hearing, Your Honor. We didn't have any of the discovery at that time. And this hashtag YSL, I mean, the word slime isn't even originated in Atlanta, Your Honor, as far as I know. I went around on the internet a little bit. There's a mixtape by VOD up in New York in 2009. It's called Slime Flu 2. And that predates a lot of this. So I think they're trying to just take advantage of this cultural term. Again, slime or die. It's just a play on words from vote or die, Your Honor. And it has nothing to do with whether or not someone's committed a crime. That's done through evidence. And the state still has not proffered anything beyond mere presence and mere association. The Forever Homicide, Your Honor, that's a song by Mr. Wani Lee, performed by the character Slime Life Shorty, where it's a play on words of homicide and homicide. I'm always by my homie's side. And it's just a little play on words with the word homicide. Mr.
This
Farley,
is so
you heard from his
funny
principal,
to
has never even been
watch.
violent at school.
These white
Gang
niggas is
behavior begins sometimes at
hilarious.
12 years old, 13 years old. This is so out of the ordinary as an allegation.
These
Who joins
white
a gang when
niggas
they're
is
24 years old and never even got in a
hilarious.
fight at school, and yet they're a homicidal person that can't even get a bond when they're presumed innocent. So, Your
Yes,
Honor,
that is correct.
this
Nori did
YSL
start
has
the
been
word
hashtagged
slime.
over
That is
21 million
correct.
times all time in Instagram. And so because
I
Mr.
thought
Farley has a
Nori was
page that
blood for
also has
mad
T.I.
long
and
because of
Future
that.
on it, wearing his hats in addition to Mr. Williams, it's just not, there's still nothing now that we have the discovery, and now we also have an actual
And they didn't
live
even get to
witness, Ms.
Young Thug
Ford,
and Gunna yet.
to correct
They
the
going through
misstatements
all
of
the
the state in the
YSL
prior
niggas
bond
trying to
hearing,
get
and
bond.
it's clear now
So that's what
that
the
Mr.
lawyers is
Farley
doing
is not a
now. They trying to
significant
get
risk in
bond.
any of the IL factors, and there are ways to mitigate these baseless allegations of witness tampering that he has nothing to do with and has been reported all this time. And if they have his phones and they have these incriminating things, and yet that's all they can still proffer, Your Honor, he definitely deserves a bond. It's just the conditions are at issue now, and we're willing to submit to any conditions from this court whatsoever, Your Honor.
I thank you, sir. All right, Mr. Menendez and Mr. Geary and Mr. Farley. I've had an opportunity to reconsider the what has been proffered in this particular from the 523 hearing in this case. Mr. Menendez, I don't find any change in circumstances. I do agree with the state in this particular situation. At a minimum, your client still poses a threat to persons and property in the community and poses a threat to intimidate witnesses or otherwise obstruct administration of justice. So I'm going to deny bond at this point in time. He's still on trial for the 9th of January of 2023. And if you file any other motions, let me know, and we'll go ahead and hear those expeditiously, okay?
All right, thank you, Your Honor. Good to see you.
Can we arrange since we've got counsel?
Yes, Mr. Farley and Mr. Menendez, since you are here and the new indictment has in fact come out, Mr. Menendez, would you like to go ahead and have me arraign your client on the re-indictment?
Yes, Your Honor, that's fine. I went ahead and filed a packet of consolidated motions.
Okay.
And all I can think of now is that in light of the bond denial, I do intend to join in Mr. Steele's speedy trial motion.
We'll file it and we will move on it accordingly. But in terms of the indictment, 22 SC 183572, is it your desire to waive formal arraignment on behalf of your client?
Yes, Your
Otherwise,
Honor.
have the court enter a not guilty plea on behalf of your client, and for you to have at least 10 days upon the receipt of discovery to file any motion.
Yes, Judge, we waive formal arraignment, plead not guilty, and we would ask that in light of the massive amount of discovery and the several co-defendants that we be allowed 60 days till after the completion of discovery to particularize or file any.
I'll give you 30.
Okay.
Because I'm still planning on moving on this case on the 9th of January. So, and I believe you've been given some discovery already, correct? So this would just be updated discovery. They just re-indicted to, for other reasons, but I'll give you 30 additional days, okay?
All right, thank you, Judge.
All right. Then, and then it'll remain on the 9 January 2023 calendar, okay?
Understood.
All right, thank you very much, sir.
All right, I'll see you on the 8th.
All right, okay. All right, Mr. Farley, you can be excused at this point in time, sir. Thank you. No, unless he has any other motions that have been filed, no.
Okay. I'll let the court know, Your Honor. I do anticipate filing a motion to sever, but I'll just keep the court updated with.
If you file such motion, let Mr. Chamberlain know, and I'll make a decision as to whether or not I hear on the 8th or some other date, okay?
Yes, sir. Thank you.
All right, thank you, sir. All right, let's see who else we have left. That needs to at least proffer at this point in time. I believe that we have, let's see. Ms. Omana, can you tell me who's in N506?
One moment, Your Honor.
Thank you, madam.
Your Honor, Mr. Garland and I both have an afternoon conflict. If we could do our waiting whenever the court's ready for Mr. Kitchens, that would be helpful.
Madam, I'll go ahead and take that up next, okay?
Thank you, Your Honor. I think he's already on the Zoom.
He is.
Your Honor.
Just hang tight. And folks, Ms. Nova, I understand you're eager, but I need to take a comfort break. I've been here since the time we came out, and I'm over 50.
Of course.
And so's Mr. Apt and several other people, Mr. Geary. We would all like to take comfort for just a few minutes. So if we could maybe have 10 minutes, that would be great. I think that would probably be appropriate under the circumstances. So I'm going to take 10 minutes. We'll see who's here at that point in time. I'll go ahead and take Mr. Kitchens up at that point, okay? You can be excused, thank you.
Alright, so these niggas about to take a 10-minute interlude, and then they come in straight back with Sergio Kitchens, who is also known as Gunna. So Gunna is the next one up for his motion. I guess they doing a motion to see about bond, to reconsider bond. So they probably gonna leave Young Thug for last because it's Young Thug. But they got Sergio Kitchens up next. On my soul. So they got Sergio Kitchens up next. I had to mute that shit real quick. Make sure y'all hitting that like button, that subscribe button. You know what I mean? And let me know what y'all feel in the comments, man. Do y'all think Young Thug and Gunna is going to get reconsidered for bond today? I don't. You see what happened to the clothes designing nigga? They didn't even let that nigga go, and that nigga just do t-shirts. This shit is a bit more extensive than y'all niggas think, man. You know what I mean? But they on a little 10-minute break, and then they're gonna come back straight into Gunna's case, and then after Gunna's probably gonna be Thug. All right, so y'all niggas stay tuned. Make sure y'all hitting that like button, subscribe button. Matter of fact, I'm gonna throw a little commercial real quick since they on a break. What the fuck is you talking about? Let's get it. Oh yeah, it's getting spooky out here, champs. Respectfully, them All My Soul shirts is popping. Y'all asked for it, y'all got it. In all different type of colorways. It's all there on the website. Y'all make sure y'all go over to wearetough.com and go ahead and copy your All My Soul shirts, man. Let these niggas know you are very serious with what you talking about, man. All My Soul, you know what I'm saying? Go ahead and cop your All My Soul shirts today. Fuck is you talking about? On my soul of all souls. Let's get back into the sound, man. Let's see what these niggas is doing. Sergio Kitchens is up next. That is Gunna. Let's get it.
Got it. You see, got it one. Oh, yeah.
Okay, guys, everything y'all are saying is being recorded. Don't talk. Don't even talk to each other. Sergio, not you. Just don't say anything. Sergio, I'll try to come see you tomorrow, or at least do a call tomorrow, okay?
It gotta be your pivot.
Christian. Yes. Can you tell my family to rebook their visit?
Hold on, it's hard for me to hear you. Let me, don't say anything. Don't say anything. I just don't want anything you say to be recorded. Everything you say,
Well, this nigga don't understand that he's being recorded while he in that cell right now? What the fuck? All I hear is this nigga Gunna talking.
Nah, Nah, it was about a
Relax,
business
nigga.
shit.
You are in jail, champ.
It was
This is
about
how it
business
goes.
shit.
You gotta wait a long time, champ.
I'll do a video call in our house.
Yeah, I was just telling them to reschedule it. Okay.
Can you see me now?
Yeah, I can see you. I was telling you just tell my family to rebook the busy behind.
Okay, I love it. All right.
Go again. Got my name.
You could tell that nigga want to rat so bad. Nigga can't even wait till his name is called. Champ, you're up next. Relax.
I let her do it. You are not counsel, and I have you sit outside.
Oh, I thought that was my sound. That's they sound. I don't hear shit. I guess it'll come back on though. Y'all niggas make sure y'all hit that like button, that subscribe button, man. Gee, what's poppin'? Yeah, man. Yeah. You see what happens when niggas is facing time, man. You see what happens. But I ain't gonna hold you. We waiting for them niggas to turn their sound back on. They got Gunna up next. I'm about to refresh this shit and see if something happened. Hold on, yeah. Refresh that shit real quick.
Wheatley Vodka. No big shot celebrities or faux fruit flavors. Just the best distillery, doing not 3 or
Oh no, it's just them. I guess they muted up because this nigga Gunna kept talking. So as soon as the judge come back, that's when the audio is gonna come back on, man. Y'all make sure y'all sharing this shit, man. Y'all make sure y'all liking this video, man. Let's see what happens with these niggas, man. Let me put on some music for us until they come back, man. These niggas said 10 minutes. Of course they gonna lie because this is court. but it's all good. Hit y'all with that music real quick. And we waiting for these niggas to come back. We waiting for the judge to come back. They got Sergio Kitchens up next, man. Let's see what happens. Yeah, man. So we just waiting for this good old judge to come back. We waiting for this good old judge to come back. Y'all make sure y'all hitting that like button, that share button. They having a motion hearing to see if these niggas can get bond, man. You know what I mean? Which I sincerely doubt is going to happen. But the judge will be back at any moment now. I just didn't want to have niggas sitting in silence. You know what I mean? But make sure y'all hitting that like button. You know what I mean? Let me put this back on big screen too. My bad, y'all. There we go. I guess by 10 minutes. I guess by 10 minutes they meant a half hour. Shit is crazy. Y'all make sure y'all hitting that like button, man. Hitting that subscribe button. As soon as the judge come back, which he probably eating a meatball sub, but when they come back, they starting back with Sergio Kitchens, aka Gunna. They trying to get Bond in this YSL Rico case. Niggas just trying to get Bond right now. So I think that nigga Gunna is in the top right of that big TV screen over there. And then they should have Young Thug afterwards. So y'all make sure y'all sticking in there, man. As soon as y'all see that good old judge come back, they're gonna turn the sound back on. All right, let's go. This shit was only supposed to be a 10-minute break. This shit is supposed to be a 10-minute break, but this what they do in court, man. This what they do in court, man. They can talk about 10 minutes and then it should be an hour long. Waiting. Well, let's go. If y'all sticking in there with me, man, make sure y'all hitting that like button. Make sure y'all hitting that subscribe button. Go over to my YouTube page. Hit that good old subscribe button, that like button. Let's go.
I have the video, I mean, not the video, I have the audio of him asking that guy now. Just, no, I don't have video, I just have audio from my thing. Because he just did like, from 0 to 60. He didn't get tased though, because my sister's a retired police officer. She's like, our son, it's all high pitched. I said, yeah, he was just being a rough.
Here we go, y'all. They about to start back up with Sergio Kitchens, aka Gunna. This is a motion for reconsidering of the bond. Niggas is still trying to get bond instead of just going to trial. You're gonna have to go to trial, champ. But let's see what happens. They turn the sound back on. I mean, it's ready to go. Make sure y'all leave them like.
Send it to a few people.
Yeah, hit the like, leave some comments in the chat, man. Let's go.
Thank you, Steve.
All right, I'm gonna take up Mr. Kitchens at this point in time, folks, and we'll see who else is on the platform.
My client's Dom, calendar today, may I be excused?
Yes, you may, of course, if you like. And I'll see you on the 8th. You got an in-court notice, and we'll send you out also a formal notice as well. Okay?
Thank you.
You're welcome, sir. Madam, hold on a second. Please. All right, Ms. Novak, I have your client's waiver. I'm going to mark it as court 2. What were you going to tell me?
Actually, I think Dave has something to add.
Yes, ma'am.
Your Honor, our position, because Mr. Winfrey is not in custody, and that's the only conflict we've identified with Mr. Sadow. Once we have, if Mr. Kitchens does decide to go ahead and waive that conflict, we would not have any further concerns about disqualification of Mr. Sadow beyond Mr. Kitchens' waiver, as Mr. Winfrey is not in custody at that time.
Yeah, like I said, I'm not going to deal with Mr. Winfrey today because he's not represented. So, okay, that's fine. Ms. Novak, you still want me to go through the waiver with Mr. Kitchens?
I think we should.
I think we should as well, too. All right, Mr. Kitchens, let's see if we can unmute you. All right, sir,
That's
can you hear
Gunna,
me?
y'all.
Yes, Your Honor.
All right, sir, can I get you to raise your right hand for me, please? You solemnly swear or affirm the evidence you'll give in the case now and hearing speak the truth, whole truth, and nothing but the truth, so help you God so affirm. One more time? Yes?
Yes.
Okay, you can put your hand down. Okay, Mr. Kitchens, I am holding a document which is entitled Conflict Waiver. Okay, I just want to go through that with you briefly, okay?
Yes, sir.
Okay, all right. It starts out with your name. It says, my name is Sergio Kitchens. I'm a defendant in Fulton County Superior Court, case number 22 SC 1822773, which has been re-indicted under 22 SC 183572. Did you have an opportunity to take a look at the both indictments, sir?
Yes, Your Honor.
Okay, all right. And this is a RICO case with 28 defendants, including Mr. Winfrey. We're not going to talk about Mr. Winfrey today, but you do understand that, correct?
Yes, Your Honor.
All right. You're represented by Mr. Sadow, Mr. Samuel, Mr. Garland, and Ms. Nove. Is that your understanding? Is that correct?
Yes, Your Honor.
Okay, all right. And it is your understanding that in late 2015, that Mr. Winfrey hired Mr. Sadow in Cobb County Superior Court case number 15-9-276528 to appeal his case to the Georgia Court of Appeals and then the Georgia Supreme Court. Is that your understanding?
Yes, Your Honor.
All right. This is in the conflict waiver I'm holding up right here, and it bears your signature on the second page, and the witness is Ms. Nove. This is the document I'm reading from. So did you have an opportunity to take a look at this document and sign this document?
Yes, I did.
It would have been dated the 10th of June of this year. So I'm holding up the documents that's been submitted to the court. So that's the document I'm referring, okay? As Court 2.
Yes, Your Honor.
Okay. All right. The Supreme Court reversed his conviction in Winfrey versus the state 304 Georgia 94. And that's further been cited at 816 Southeast 2nd 456 2018. And then Mr. Sadow then represented Mr. Winfrey in Cobb County where his offered plea was entered. Is that your understanding?
Yes, Your Honor.
All right. It further goes on, your waiver further goes on to say that Mr. Sadow continued to represent you in this RICO case that's here in Fulton County after and under the 2 indictment numbers that the court has already referenced. So you've spoken to Ms. Nove and discussed the types of potential conflicts that could come up with a lawyer who previously represents a defendant who later represents another defendant in a case in which both are co-defendants. So did you have an opportunity to speak with her to your satisfaction on that issue?
Yes, Your Honor.
Okay, all right. The waiver also further enumerates 6 points. The first one is the state could offer to dismiss the case against one defendant, reduce the charges, or agree to a lower punishment if that co-defendant would testify against the other. You understand that?
Snitching.
You also understand number 2, that a witness might say something or evidence might come in helpful to one co-defendant but harmful to the other. She talked with you about that, correct?
Yes.
All right, number 3, the lawyer may want to use a defense theory, witness, evidence, or argument that is helpful to the lawyer's current client but harmful to the lawyer's former client. You understand that?
Yes, Your Honor.
4, during closing argument, the lawyer may want to argue that the evidence against his current client is less than evidence against the former client. You understand that?
Yes, Your Honor.
All right. And then number 5, if there's sentencing, the lawyer may want to argue that his current client is less culpable than his former client. You understand that?
Yes, Your Honor.
And then number 6, the lawyer may have learned something from the former client that helps the current client.
I thought
but
it was
hurts
middle
the former
fingers
client.
to the judge,
You
y'all.
understand that?
Sir,
I
understand,
thought
Your
it
Honor.
was
All right,
fuck the
so Ms.
judge
Nove
and the DA.
went over examples of how these potential conflicts might come up in this case. Is that correct with you? Mr. Kitchens, are you there? I froze up, I think. Oh, he's back. Okay. All right, Mr. Kitchens, what was the last, can you hear me?
Yeah.
What was the last thing you heard me say?
The last one,
I can't hear you, sir.
the last time I didn't hear what you said.
All right, let me go over this last part here. The last thing I said was that Ms. Nove, did she go over examples of how these possible conflicts, the ones that I've enumerated in 1 through 6 on your waiver might come up in this case. Did she talk with you about those? Give you some examples?
Yes, Your Honor.
Okay, all right. Your waiver goes on to say that you understand these potential conflicts. Is that right?
Yes.
Okay, but you are certain that no actual conflict exists and that no actual conflict will ever exist.
Yes, Your Honor.
And that's your understanding, all right? Is that correct?
Yes, sir, that's correct.
All right, do you fully understand what Ms. Nove explained to you?
Yes, Your Honor, I fully understand.
Okay. Do you understand you have the right to select a different lawyer?
Yes, Your Honor, I understand.
However, you don't want you don't want a different lawyer, is that correct?
That's correct.
You want Mr. Sadow to fight for your innocence and freedom, is that right? That's what it says in the waiver. He's back. Okay, good. Well, okay. The last thing I said, sir, was you choose Mr. Sadow to fight for your innocence and freedom. Is that correct?
Yes, Your Honor, that's correct.
All right, and you waive any potential conflict and ask that the court preserve your right to choose a lawyer who you want to protect you. Is that correct?
Yes, that's correct, Your Honor.
And you make this statement voluntarily, knowingly, and freely in the presence of Ms. Nove. Is that correct?
That's correct, Your Honor.
All right, and you declare under the penalty of perjury that the foregoing waiver is true and correct. Is that right? Did you hear the last thing I said, Mr. Kitchens?
Declare.
You heard me? Okay, so you declare under the penalty of perjury that the foregoing waiver is true and correct. Correct? Is that right?
Correct, Your Honor.
Okay,
Yes.
all right. Do you offer this statement freely?
Yes.
Did anyone force, trick, or otherwise cajole you into entering this waiver?
Yes, I heard you, Your Honor.
Let me go through this one more time. Do you offer this statement freely and voluntarily? No one otherwise forced or tricked you or in entering this waiver. Is that correct?
Yes, that's correct, Your Honor.
All right. Okay. All right. Anything else, Ms. Nove or Mr. Geary? I did already. Okay, no problem. No worry. Okay, anything else? Anything else is in terms of the waiver? Okay, all right. Any questions on behalf of the state or anything that you want me to inquire about?
Nothing from the state, Your Honor. We believe that satisfies any conflict from Mr. Sadow. And should Mr. Winfrey be captured, we would just ask the court to fire him at that time.
Yeah, I'll inquire about Mr. Winfrey when he becomes within the breast of the and jurisdiction of the court. Mr. Kitchens, I'm going to go ahead and let Mr. Sadow continue to represent you, understanding that in the future, if a conflict does arise, you are welcome to raise that to the court, or if I see it, I may raise it on my own motion or depending upon the circumstances in this case, okay? I think he's still frozen.
He tried to say okay.
All right, Mr. Kitchens, did you hear the last thing?
Yes, Sean, I heard what you said. Thank you.
Okay, all right. Anything else in regards to Mr. Kitchens? Can we rearrange him? Okay, all right, okay. Mr. Garland, would you like to otherwise arraign your client on the new indictment, that being 22 SC 183572?
new indictment.
Okay, I will authorize for you to waive formal arraignment. I'll enter a not guilty plea on behalf of your client. I'll otherwise give you 10 days upon the receipt of new discovery to file any other additional motions. Do you have any other issues, sir?
If we got 30, Your Honor.
30. Okay, 30. All right, 30.
It's because you like me so much.
Okay, all right, anything else? I got a mask on, thankfully. All right, okay, anything else?
And I think we worked with the state where they've got our hard drive, so we'll get the remainder of the discovery.
Do you have any other motions outstanding that need to be heard on the 8th of September, madam?
Not at this time, Your Honor.
Okay, all right, just want to make sure. All right, okay, all right. Unless you have anything else, then I will excuse Mr. Kitchens and excuse you all, councils, and thank you for your patience, okay? All right, okay, cool. All right.
All right, so they just wanted to arraign this nigga on his
Anybody else that's with us this
indictment
today that we
because
can
he
do
was he
waivers
had
for at
drugs
this
in the
point?
cell and shit. So that's basically what they just did, and his lawyer into the not guilty plea for that new indictment.
N506.
Hold on one second. All right, Ms. Mormon, you like to have a bond hearing, is that correct? How come you can't do it now? I got space issues. That's why I'm trying to kind of do this, and it was supposed to be heard today. Okay. Yes, sir. Bond was filed, I get motion for bond was filed on 6/28/22, Mr. Geary.
I don't expect we'll close the motion for bond. He was convicted of murder last fall, and he had a life sentence. He ain't going nowhere. Respect him.
He's not here on it. It's been reversed. He's out on it.
It's been. I'm again wrong. I'm closer to it.
Hey, you can't be right on everything, Mr. Geary. It's all right, it's okay. All right. So can we do his bond today? Okay, all right. Thank you, madam. All right, okay, Mr. Greer? Ms. Amana, can we unmute N506, please, madam?
Yeah, bro, they not
Yes,
getting no
Your
bond.
Okay.
The reason why Gunna was in there was because, as a matter of fact, which is crazy because Kevin Lyles was just there. So I don't know why Kevin Lyles. If y'all rewind the shit, Kevin Lyles' picture was right next to Gunna's on the bottom left. So unless Kevin Lyles is in there for Young Thug,
okay, Mr. Greer,
I think
can you hear
Kevin
me,
Lyles
sir?
is in there for Young Thug. So they're probably gonna bring
Okay, all
Young Thug in shortly.
All right, Ms. Mormon, if you'll go ahead and state what all the factors you wish the court to consider and any other relevant facts, I'll let the state respond and hopefully I'll make a decision, okay? All right, go right ahead.
To address the ALF factors, Mr. Greer is 33 years old. He's a lifelong resident of Fulton County. If released on bond, he will reside in Atlanta with his mother. His mother and the significant amount of his family is here today. He has 3 grandchildren. His entire family is here from Georgia. When he was notified about the outstanding indictment for this case, he was on tour in California. He did immediately jump on his tour bus, come back to Atlanta, and turn himself in. He's not flight risk whatsoever. As far as a risk to reoffend, he has no prior convictions. As the state has discussed, he was convicted in 2010 of murder. Since that conviction, he did take it up, it was reversed and remanded back down. He's been out on bond since 2019 for that. But outside of that, no prior convictions. The issue with the intimidation of the victims and witnesses, Mr. Greer is not accused of being in any gang. He doesn't have any tattoos. He hasn't been classified as being a gang member. He's not accused of any violent crimes in this indictment or prior to, aside from the non-reverse case. He's not been accused of any direct contact with any victims, any intimidation, any having anybody else into the state offered that information earlier as well. This is a grand case, as you know, and not only that, there's two defendants on this case that are known worldwide with a magnitude of fans. So I don't believe Mr. Greer should be held accountable for any threats, alleged threats. Again, we haven't had any discovery or these allegations of threats. That's kind of out of his hands, whether he's in custody or outside of custody. Mr. Greer is not accused of intimidating or threatening any victims or witnesses in this case. And as far as danger to the community, he, again, he's not alleged to be gang affiliated. He has been out on bond since 2019. He had, as far as his time that he did serve in custody, he hasn't had a DR since 2013. He poses no threat. The time that he's been out, he's had no issues until this came up. He did have count, I think this count 13 in this case is the theft or receipt from firearm. He was arrested for that in 2020. It was no cost. He was charged with possession by a felon. He essentially wasn't a felon, so that charge was no cost. Mr. Greer does meet all the factors in this case, and we understand that this case is set to go to trial in January. But given that he does meet all the factors, all four of the factors, we do ask that a reasonable bond is granted, and we are offering 24-hour home confinement at his mother's residence in Atlanta, and whatever other conditions the court is comfortable with ordering.
Okay. All right, thank you, madam. Yes, Mr. Geary?
A few things. I want to speak to that as part of the council statements correct and threatened. He actually tried to set up their murder, and that is caught on wire at the jail. He was out on bond after that in 2019. During his stay in prison, he's a documented fellows gang member with extensive gang conduct in jail. He's part of the hybrid gang concept we've spoken to the court about. He's both a good fellow and he's YSL. He is also Mr. Williams' brother. He is on videos, throwing gang signs with weapons. He has the council told you the charges were dropped because he wasn't a convicted felon. Well, the other problem with that, he uses the weapon was also stolen. So there's a theft by receiving charge, and that's what's count 13 in this judge. Judge, he is in leadership in that gang, and since he's been in there, Judge, there was not since he's been there, before he got arrested, Judge. We had him on a wire talking to people on a contraband cell phone about how to smuggle more cell phones and other illegitimate items into the jail.
Damn.
Through a window that had been broken. And that, along with an attempt to have someone in the jail murder an individual who threatened a fellow gang member in the jail by someone in the jail, that makes him not only a danger to the community, that makes him a danger within the jail. But Your Honor, he is a danger to commit additional felonies. He's a danger to the community. I can't say that he's a danger to flee. I don't know that to be true. But for the rest of them, I think he's a danger to intimidate witnesses, to the community, and to commit additional crimes, which he has done right up to the point when we arrested him on these charges.
Your Honor, but
You may not, you can talk.
Your Honor, the state proper information about Mr. Greer being a member of Goodfellas. I'm sure this has come up many times that typically anyone that is from a certain area of Atlanta, when they go down the road, they are identified as a Goodfellas. In classifying him as being a Goodfellas, I don't believe that there was anything other than, I don't think there was anything that, aside from where he's located in Atlanta, that was why it was considered a Goodfellas. Also in being YSL, there's no identifiers other than Mr. Williams being his brother. There's no photos of him with YSL clothes. There's no tattoos. There's no, the state alleges gang signs, I haven't come across the gang signs that have been alleged yet, it's just a problem. As far as Mr. Greer being in a leadership position, the indictment states out very clear the members that they're accused of being in a leadership position, and Mr. Greer is not one of them. He's not charged in any gang counts in this indictment. And for those reasons, Your Honor, I do think he does meet all four AR factors, and I would ask the court to consider a reasonable bond.
Thank you, madam. All right, Ms. Mormon and Mr. Geary, the court's had an opportunity to consider the proffers for a bond in this particular circumstance. I do believe that he poses, he being Mr. Greer, poses a risk of committing additional felonies, and he poses a risk of intimidation of witnesses or obstruction of justice, administration of justice. For those reasons, I'm going to deny him bond at this point in time. Ms. Mormon, if the situation should change, you're welcome to file a motion for the court to change in circumstances or reconsider his bond. I certainly will do that. But at this point in time, I'm going to leave bond. I'm not going to grant bond at this point in time. And do we need to, let's see.
We need a waiver and a
Yeah. Yes, I'm going to do that right now. For what? Tell me about that. There we go. Mr. Geary and Ms. Mormon, I am aware of that other case. It is a 10 SC case. I believe it's 10 SC 92020. So I will just put it, do you wish to go ahead and deal with that particular case? Can I, Ms. Mormon, would you like to waive arraignment on both those two cases, the 10 SC case as well as the indictment then under the new case, which is
22 SC.
the 22 SC
2573.
22 SC 183572. That's the new case, correct?
You inverted two numbers, 182573.
It's 183572. That's the re-indictment.
Yeah, the calendar has y'all are gonna have to probably correct. See, the clerk has written on the 22 SC 183572.
That's the re-indicted case. Yes.
Yeah, that's the re-indicted case. Okay, all right.
Okay, so the 10 case is the motion for new trial that Judge Newkirk granted. So the question for me is, do you want me to keep this case along with that case to deal with it, or put that to the side? What would you like with the 10 case?
He said for trial, if
Yeah, we'll just put it in a trial posture, and put it on a trial calendar. In fact, it can go on that 9.
Because we need to keep account for the 10.
I'll put it on the 9 January 2023 calendar, madam, and I'll probably, unless we've got one, and more than likely I will move it as I get my other trial dates come later this fall. Okay. But just for accountability purposes, I'll continue. I'll go ahead and just lump that case with it. But as for the new indictment ending in 572, Would you like to otherwise waive formal arraignment, have the court enter a not guilty plea on behalf of your client, otherwise have at least 30 days from the receipt of discovery to file any motions, madam? Okay, all right. I'm going to go ahead and put it on that 9/23, January 9th, 2023 calendar, okay? And and I'll also track the 10 SC 2020 case, but, or the 10 SC 92020 case. We'll put that on another calendar, okay? All right, thank you. All right. Mr. Greer, you can be excused at this point in time. Your attorney, Ms. Mormons, will talk with you a little bit later on, okay? Okay, oh, do we have a waiver issue with him? Okay, all right. Do you want to go ahead and take that up now?
Yes, please.
Okay, all right. What?
My calendar. Yeah.
All right.
And make an additional inquiry, please.
You can.
You had mentioned earlier, asked me how to prepare an order. Ostensibly, I presume this is denying the state's motion to remove Mr. Steele as attorney for Mr. Williams. Because there are 4 individuals who are mentioned in the reason for conflict, and we've addressed one, we're about to address the second one, and the other one will not be addressed until at least the 8th. I would court for law, I'm drafting that order until that's all.
No, go ahead and do the order for the ones that we have for today. I'll enter a supplemental order when those 2 folks are taken up, okay?
Yes, sir. May I say something else also?
You can.
Earlier, the court made reference to, I sort of asked some questions, some clarifying questions with regards to our manner of proceeding, and I think I take some exception to the court's belief, assertion at that point that
This is, okay, since you brought it up, no, you may not at this point in time, because you interrupted me to begin with, okay? We're here, Mr. Adams, here's the thing about it. You have to be patient with the court. You have to be patient with the court because I got a lot of freight I'm trying to manage. I'm always going to let you have and consider everything that you tell me and any motions that you file. But what you do is when you jump me, meaning that my procedure, or you jump in front of other people, then that it doesn't sit well. So I'm just going to tell you, if I offended you in any way, please take my apologies for it. It wasn't my intent to do so. I consider you to be a very fine attorney, and I've known you professionally for over 20 years. But having said that, I do get to control the method and manner of how things go in the courtroom.
I understand that, Judge. This is your courtroom, but I was asking a question to get some clarification, and I just feel like the court telling me to sit down or what I can do is take my seat was not appropriate. I treat the court always with deference, with respect. And the only thing that I ask is that the court treat me the same way.
I'm required to do that, Mr. Adams. We both are under the rules of professional responsibility. Okay? Anything else, sir?
That's all.
Okay, all right. Okay, who do we have at this point in time? Okay. Let me see if I can get Mr. Greer's waiver. Okay. Let me mark that as the next court exhibit in order. I want to say it's court 3. Is that correct, Ms. Weaver? Yes. Okay, all right. Okay, Mr. Greer, can I get, Ms. Amana, can you go ahead and unmute Mr. Greer, please? And the reason I muted him again for Cal folks is because there's a lot of background noise in the jail. So, yes. Okay, all right, I think he's unmuted now. Mr. Greer, again, good afternoon, sir. Sir, I'm holding at this point, let me go ahead and swear you in at this point in time. Can I get you to raise your right hand for me, please? Do you solemnly swear or affirm that the evidence you'll give in the matter now in hearing shall be the truth, the whole truth, and nothing but the truth, so help you God, so affirm?
Yes, Your Honor.
I'm put your hand down. Okay, all right. Sir, I'm in possession of a waiver for you. It's addressed from the law office of Lawrence J. Zimmerman, PC. And I believe it was dated or authored on the 20th of May of 2022. All right, did you have an opportunity to to read that particular document?
Yes, Your Honor.
Or before Mr. Zimmerman penned it, for you to discuss the things that we'll cover in regards to conflict?
Yes, Your Honor.
Okay, I'm gonna read it because it's very short. It just says, Dear Brian, I've met with my client, Quantavious Greer, regarding any potential conflicts of interest. He met with you, is that correct?
Yes, Your Honor.
All right, that he being Mr. Zimmerman, right?
Yes, Your Honor.
All right, and he advised you of all the issues regarding your prior representation of him and your current representation of Mr. Jeffrey Williams. Is that correct?
Yes, Your Honor.
And then you discussed with Mr. Zimmerman all the issues regarding potential conflicts in this matter. Is that correct?
Yes, Your Honor.
Is that right?
Yes, Your Honor.
Okay, and that you are he is insistent that you represent Mr. Williams, and he waives any conflicts of interest. Is that correct?
Yes, Your Honor.
And that it further says, I advised him that the court may ask him questions about these issues on the record. Is that correct?
Yes, Your Honor.
Did he tell you that?
Yes, Your Honor.
Let me just kind of ask you a couple other additional questions, okay? Because this is I just want to make sure that you understand what you're waiving at this point in time. Do you understand that the state could offer to dismiss the case against one co-defendant, reduce the charges, or otherwise agree to a lower punishment if that co-defendant would testify against the other?
Yes, Your Honor.
Do you also understand that a witness might say something or evidence might come in helpful to one co-defendant but harmful to the other? So it could be helpful to somebody else and be harmful against you. Do you understand that?
Yes, Your Honor.
Also, do you understand that the lawyer may want to use a defense theory, witness evidence, or argument that's helpful to the lawyer's current client, and that would be Mr. Williams, and harmful to you? You understand that?
Yes, Your Honor.
During closing argument, the lawyer may want to argue the evidence against his current client is less than the evidence against the former client. You understand that?
I understand, Your Honor.
All right. Do you also understand that if there's sentencing, the lawyer may want to argue that his current client is less culpable than his former client?
Yes, Your Honor.
Do you also understand that the lawyer may have learned something from the former client that helps the current client but hurts the former client?
I understand, Your Honor.
All right. Did you give this waiver freely and voluntarily? Means your own decision to enter a waiver this afternoon as to counsel, waiver of potential conflict of interest as to counsel.
Yes, Your Honor.
And you do so freely and voluntarily. It's your own decision. Nobody's forced or threatened or tricked you into doing so.
Yes, Your Honor.
If you had an opportunity to speak, to fully consider this waiver
Yes, Your Honor.
and any potential conflicts of interest.
Yes, Your Honor.
All right. Any further inquiry you want to make, Mr. Adams?
No, sir.
All right. What about you, Mr. Geary or Ms. Rosenwasser? Okay, and I've admitted that is number 3. The letter from Mr. Zimmerman as Court Exhibit 3. Okay, anything else? Mr. Adams? Sir? Okay, all right. can we go ahead and arraign Mr. Williams on the new charge or the new indictment?
Yes, sir.
Okay, all right. Do you want to go ahead and waive formal arraignment, otherwise have the court enter a not guilty plea, and otherwise have at least 30 days to file any motions on under the new indictment, that being 22 SC 183572, sir?
Your Honor, we waive formal arraignment. We do enter a plea of not guilty on the new indictment. We do ask for what the court had granted us previously. Previously, the court had given us 60 days from the receipt of all discovery to file particularize any motions. We ask for that at this time.
I'll give you 30 days, and then the only reason why is because you all have started on the discovery process. I don't know whether or not. I suspect you've probably gotten some discovery, but I'm flexible with that. But let's go with 30 for the time being, okay? Okay.
And Judge,
Yes, sir.
of course, our waiver of arraignment and plea not guilty is subject to the statements made previously by Mrs. Steele in regards to
I will incorporate those and include those, and I believe that Mr. Geary owes an order in that respect, and we can incorporate that by reference, okay?
Thank you.
Okay, are there any other waivers that I need Mr. Adams, I need to take up in regards to Mr. Steele that are here today? I don't know if there are any, because
Yes, Your Honor.
yeah, Ed Adams is on, and as well as Ms. Merchant, and I think that they have, Martinez Arnold. Let me see if he's on. Is Mr. Arnold, are you on? Martinez Arnold? Are you Mr. Arnold?
Yes, Your Honor.
Okay, I guess he is there. All right. Okay, all right. Let me see if I have his waiver. Ms. Merchant and Mr. Adams, thank you for your patience with us today. I'm going to mark this one as court exhibit next in order, and that would be, I think, courts 4. Mr. Arnold, where are you, sir? Can I get you to raise your right hand for me, sir, if you wouldn't mind? Do you solemnly swear or affirm that the evidence you'll give in the matter now in hearing shall be the truth, the whole truth, and nothing but the truth, so help you God, so affirm?
No.
I didn't put your hand down. Okay, all right. Mr. Arnold, just want to go through a couple things with you to begin with. Are you aware that Mr. Adams, on your behalf, penned, that is, authored a letter to Mr. Steele on the 19th of May, 2020?
Yes.
All right, are you familiar with the contents of that letter, sir?
Yes, Your Honor.
In terms of the waiver?
Yes.
Okay, I'm just going to go through it with you again because it's 4 paragraphs, and I'll just read it and ask you some questions as we go along, okay?
All right.
Is that all right?
Yes, Your Honor.
Okay, all right. It says, Dear Brian, I am authorized to make statements herein on behalf of my client, Martinez Arnold. I represented Mr. Arnold in the state of Georgia versus Martinez Arnold, indictment 14 SC 131032, Fulton County Superior Court, and which is a case involving a shooting at Lenox Mall. Is that the indictment that is referenced that he spoke with you about?
Yes, Your Honor.
Okay, all right. Mr. Arnold pled guilty to reckless conduct on or about February 18, 2015. That's correct?
Yes, Your Honor.
All right. I am aware of the state's motion to disqualify you, and that would be Mr. Steele, as counsel for Mr. Jeffrey Williams in the state of Georgia versus Mr. Jeffrey Williams et al. And that was under indictment 22 SC 182273. And that was the indictment at that point in time. Do you understand that?
Yes, Your Honor.
All right, do you understand the case has been re-indicted under 22 SC 183572? You understand that, right?
Yes, Your Honor.
Okay, all right. All right, and that is the matter in which Mr. Arnold, that would be you as a co-defendant. You understand that?
Yes, Your Honor.
Okay, you have to speak so I can hear you, okay?
Yes, Your Honor.
Okay, all right, thank you. The motion to disqualify is based in part on the allegation that you represented Mr. Arnold on matters relating to the 14 SC 131032 case. That's your understanding, correct?
Yes, Your
And
Honor.
Mr. Steele represented you in that case, and he's representing Mr. Williams in this matter. You understand that?
Yes, Your Honor.
Okay, all right. I spoke with Mr. Martinez Arnold. This is Mr. Adams, okay? Regarding the state's motion to disqualify you as counsel. I explained to him what the state alleged with regard to you, specifically you, that Brian Steele represented Mr. Arnold on matters relating to the indictment we just mentioned, 14 SC 131032. I further explained to Mr. Arnold, that was you, the relevant law and ethical concerns at issue, and specifically that you're entitled to conflict-free counsel, and that you are representing Mr. Williams in this indictment, 22 SC 182273, which is now indictment 22 SC 183572, in which you're a co-defendant. You understand that, right?
Yes, Your Honor.
Okay. And he explained to you that you can object to Mr. Steele representing Mr. Williams.
Yes, Your Honor.
Okay, all right. And after providing the explanations that we just kind of went through, did you make it clear and unequivocal to Mr. Arnold that Mr. Adams, that you never represented him relating to any shooting at Lenox Mall or any other matter?
Yes, Your Honor.
Okay, basically what Mr. Adams is saying is that Mr. Steele didn't represent you in any shooting at Lenox Mall. Is that what you understood?
That's correct.
Okay, all right. Or any other matter, correct?
That's correct.
Okay, all right, and that you explained that he believes that his friends contacted Mr. Steele shortly after the shooting to inquire whether there was an outstanding warrant for you. Is that correct? Say again?
That's correct, Your Honor.
Okay. And you insist that you never spoke with Mr. Steele about the case or any of the facts and the surrounding circumstances, correct?
That's correct. Correct, Your Honor.
All right. Let me ask you a couple additional questions, just to make sure. Do you understand that the state could offer to dismiss the case against one of the co-defendants, reduce the charges, or otherwise agree to a lower punishment if that co-defendant would testify against the other?
Yes, Your Honor.
Do you also understand that a witness might say something or evidence might come in helpful to one co-defendant but harmful to the other?
Yes, Your Honor.
That the lawyer may wish to use a defense theory, witness, evidence, or argument that is helpful to the lawyer's current client, but harmful to the lawyer's former client.
Yes, Your Honor.
During closing argument, the lawyer may want to argue that the evidence against his current client is less than the evidence against the former client.
Yes, Your Honor.
If there is a sentencing, the lawyer may want to argue that his current client is less culpable than his former client.
Yes, Your Honor.
And a lawyer may have learned something from the former client that helps the current client but hurts the former client.
Yes, Your Honor.
Do you intelligently, knowingly, and voluntarily waive any potential conflict of interest that would stem from any involvement you had with Mr. Steele and or indictment 14 SC 131032?
Yes, Your Honor.
All right. And you don't have any issue with Mr. Steele representing Mr. Williams?
Not at all, Your Honor.
Did anyone force, threaten, or trick you into entering this waiver?
Yes, Your Honor.
You offer this waiver freely and voluntarily, is that correct?
Yes, Your Honor. Correct.
All right. Mr. Adams, anything, sir?
No, sir, nothing.
Mr. Geary or Ms. Rosenwasser or anything?
Nothing for the figure. We believe that satisfies any conflict with Mr. Arnold.
All right, and as I mentioned earlier, if any conflict should develop, please, notify all concerned at the earliest time possible, and the court will also, if I believe that there is a conflict, I will raise that issue and ask you all to address it. While I have Mr. Arnold here, let's see, Mr. Adams or Ms. Merchant, Madam and Sir, would you like to otherwise waive arraignment on the new indictment? Do you wish to be arraigned on that today? Or can we go ahead and do that?
We can waive arraignment on that, Judge, and we filed a couple motions on the old indictment, and then I filed a motion adopting all of those on the new indictment. And I think that would take maybe about 2 hours to be heard. We'd like to have our renewed bond motion heard with those motions. One is a motion to dismiss based on double jeopardy. One is a motion to dismiss based on a statute of limitations violation. And then one is a motion to sever. I think the sever could probably wait, but the other two dispositive motions would probably make sense to be heard at the same time as bond.
Okay. When did you file those, Ms. Merchant?
I filed them in late June, early July.
Okay. If you'd be so kind, you may have already. If you could send Mr. Kearns, my staff attorney, a copy of those as well. And I will take a look at those and we will determine if I can hear all of them on the 8th. I'll endeavor to do so, but as I mentioned, there's a lot going on. So I'll at least hear the bond. We can wait on the severance and I'll see if I can hear the other two at that point in time, because I would concur that they probably need to be heard up front, but more to follow on that, okay?
Great, thank you so much, Judge.
All right, I will go ahead and authorize you to waive formal arraignment, enter a not guilty plea on behalf of Mr. Arnold, and otherwise give you at least 30 days from the receipt of the new discovery or additional discovery to file any additional motions in this case. And we'll hear the motion for, I'll authorize the your motions that were filed in and under the prior indictment ending in 273 to carry over, and otherwise the state's going to file a motion in order for those, and I will adopt those, and I'll authorize your motions to carry forward into the new indictment ending in 572.
Great, thank you, Judge. And the date on that was the 7th of July. I just checked.
Okay. And that would be, and then I will, it'll be the 8th of September.
Okay, great.
For those motions, okay?
Wonderful, thank you so much, Judge.
All right, Mr. Adams, anything else, sir?
No, yeah, thank you.
All right, thank you all for your patience, really appreciate it today. Ms. Rosenwasser or Mr. Geary, anything else as it relates to Mr. Arnold? All right. Then I will release both of you counsels as well as Mr. Arnold, and we'll see y'all on the 8th of September, okay?
Great, look forward to it. Thank you, Judge.
Thank you, madam. Take care.
Take care.
Yes, ma'am. Unless you have anything else, Mr. Greer, I think I've excused him already. And I've also excused Mr. Arnold. Yes, sir.